Good morning, honorable members. Good morning, support staff. Good morning to the council and everyone who has logged in. Welcome to the second meeting of the impeachment committee. My name is Makashule Ghana, Honorable Ghana. I'm the chairperson of the committee. And we will proceed with the meeting this morning. But before we start with the meeting, today is the 18th of June 2026. There are two events or things that I want to share. First is to convey birthday wishes to the former president, President Thabo, who's turning 84 years today. So convey our birthday wishes to the former president as the first thing. The second aspect, Bafana Bafana, the pride of the nation, are playing this evening. The second game of the 2026 FIFA World Cup. Wish them well. May they represent the country with pride and go on to win the game, so that we will stay in the World Cup. So those are the two aspects that I wanted to share today. So the meeting, it's a special meeting of the
Chair.
Honorable Mautwe.
Thank you, Chair. We also want to congratulate you for representing all of us at the Comrades Marathon last week. We are very proud as this committee.
Thank you very much, Honorable Mautwe. Really appreciate it. Thank you. So the meeting, it's called to get a briefing from the Constitutional and Legal Services Office as it relates to the interdict application by the President on the work of the Impeachment Committee. But before we get into the briefing, I want to check with the Committee Secretary, Mr. Ngoma, if there are any apologies that you have received for this meeting.
Good morning, Chairperson. Good morning, honorable members and everyone on the platform. Chairperson, I've only received one apology, and that will be from Dr. Litchfield Chabalala. Thank you very much, Chairperson.
Thanks very much, Mr. Ngoma. I see the hand of Honorable Trolip. Please go ahead, Honorable Trolip.
Good morning, Chairperson. As you know, I'm an alternate in this committee. I'm here in that capacity. My colleague, Honorable Lerato Ngobeni, will be joining. If possible, she is out of the country on an oversight trip or a study visit with Parliament, but she will join if possible. I know the hours are difficult, but I'm here in that capacity, Chair.
Thank you very much, Honorable Trolip. Honorable Ngola.
Thank you very much, Chair. Just a housekeeping matter, Chair, which I think, if not attended to, it may affect the effective functioning of this committee whilst we are starting. I think let's have a culture, Chair, that if we were to go to a meeting and there's going to be a presentation, whether from the Legal Services Unit or wherever, we should at least be given such kind of presentations on time, so that we're able to check on them and apply our minds properly. So it's just for housekeeping, Chair. Thank you.
Thanks very much, Honorable Ngola. And I do get your point, and I apologize that the documents for this meeting circulated late, but it's in the nature of the application itself. It's an urgent interdict application, and even in terms of briefing, the legal counsel was on an urgent basis, but I do take the point. Going forward, we'll ensure that the documents are sent to members well ahead of time. But on this particular matter, because of the urgency of the issue and also the time of briefing the council was short, the turnaround time and also the submission of the document got delayed. So I apologize to all members. Just also to share, I see the hands of Honorable Daniels and Honorable Swart. I'll come to you now. Just to share with the committee that we are using a senior counsel who is separate from the Parliament's or the Speaker's senior counsel to ensure that the advice that we receive, which is an external counsel, that will then deliver the legal opinion, is also independent from that of the opinion that the Speaker will receive. So thanks. I recognize Honorable Daniels, then I'll come to Honorable Swart.
Good morning, Honorable Chairperson. I think you've covered me, if I've heard you correctly, that the legal opinion is external. That was my question I asked from the group earlier on without the courtesy of a response to it. So I take it that it is external. Thank you.
Thank you very much, Honorable Swart, and then I'll go to Honorable Dagmo.
Thank you, Chair. Can you hear me? My voice is gone, but I trust that you can hear me. Firstly, congratulations on the Comrades Marathon. I want to also thank you for calling this urgent meeting. We did write you a letter requesting a meeting, and we fully appreciate that we've got a very limited time, 8 days, to respond to the urgent application. That's 8 court days. So I wanted to just express my appreciation for not waiting till the 24th of June and calling this meeting this morning. Thank you, Chair.
Thank you very much, Honorable Swart. Honorable Dagmo.
Thank you very much, Chair. I'm joining all those who congratulated you for running the Comrades and also noting the game that will be played later this evening. Chair, I think Honorable Daniels asked a question which you have clarified, that the opinion that was shared with us is from external legal counsel. Is that correct?
That is correct.
Okay. Thank you. And then if that is correct, then I would like to ask, on the group before this meeting started, we were provided with one opinion, and then we were provided with a second opinion. And it was indicated by the parliamentary staff supporting this committee that they did a few edits, grammatical edits. But I would like to draw your attention and ask for your clarity, because there is a fundamental difference, for example, in regard to clause 12 of the first opinion. So if you have indicated, as Honourable Daniels asked, and you responded and you confirmed that that was an external opinion, why then would parliamentary staff amend an opinion, grammatical or otherwise? I think this is a really fundamental issue that we need to clarify, because clearly it's not just a language or a grammatical edit.
Thank you very much, Honourable Dagmo. I will clarify that. So the senior counsel, which will be introduced by the senior legal advisor, so M. Isaac, the senior counsel that's representing, or that we sought an opinion of, that's representing the committee, will also clarify in terms of the changes between the first opinion and the second opinion. So the edits were not done by the parliament staff. They were done by the external senior counsel. So it was just to say the senior counsel and the team have made, or they have cleaned up the document to ensure that it's fully compliant. So they will also explain and indicate the areas of difference between the first opinion and the final one. So the first one, you can take it as a draft, and the second one is the final opinion to the committee. I felt that it was important, given the time that we have, that one shares even that draft opinion with the committee, so that you can start going through the document as we're waiting for the final legal opinion, so that at least by the time it's presented, it's not all new to the team. I'll now invite Suen Isaac, who's the senior legal advisor to the
recording
to the committee,
in progress,
to just table the opinion, but also introduce the senior counsel. Suen.
Thank you, Chairperson. Good morning to the Chairperson and the honourable members. My name is Suen Isaac, a Senior Legal Advisor with Parliament's Constitutional and Legal Services. Chairperson, just as a way of introduction and to introduce our counsel, as a way of background, on the 12th of June, His Excellency President Ramaphosa served Parliament or the National Assembly with an urgent application. In the matter, the President seeks to bring an urgent application before the Western Cape High Court to interdict the first respondent being the Speaker and the second respondent being the Chairperson of the Impeachment Committee from commencing an impeachment inquiry in terms of Rule 129M of the Rules of the National Assembly. This interdict application follows the President's application to review and set aside the report of the independent panel. The applicant, the President, seeks, amongst others, an order that pending the determination of the Western Cape High Court's application in the review case, that the Speaker and the Chairperson of the Impeachment Committee are interdicted from commencing an impeachment inquiry in terms of Rule 129M of the Rules of the National Assembly. Chairperson, last week on the 15th of June, the parties to the matter did meet with the Honourable Judge President of the Western Cape High Court and agreed to certain timelines. They now seek to make these timelines an order of court. So just to appraise the members, a notice to abide or oppose must be filed by the 19th of June 2026, and any respondent who wishes to oppose the matter must file their answering papers by the 22nd of June 2026. The date for the hearing is for the interdict application is on the 15th and 16th of July 2026. Chairperson, after we were served, we received the necessary authorization from the Speaker of the National Assembly to instruct the Office of the State Attorney to represent the Chairperson of the Impeachment Committee and to brief counsel to act for the Chairperson. Accordingly, the State Attorney has briefed Advocate William Mukori SC and Advocate Mohambi to assist him in this matter. As part of the brief, we requested that the counsel prepare a memorandum to advise the Chairperson on the merits of the interdict application and the options available to him. We understand that there was a second opinion provided. The committee will just bear with the counsel as this was given under very short notice, and the first draft was provided for the members so they could have sight of the opinion, but counsel has cleaned up the opinion last night and provided us with an updated draft. He will indicate the changes and explain to the committee. So, Chairperson, with your permission, I would ask Advocate Mukori to lead us through the opinion. Thank you.
Thanks very much. Thanks very much, Suen. Before Advocate Mukari comes in, I see the hand of Honorable Daniels.
Thank you for your indulgence, Honorable Chairperson. I've just heard that there was a second opinion. I just want clarity. The second opinion that's just been referenced, is it the second opinion from another legal firm, or is the second opinion the one that's just been tweaked?
It is the one that has been tweaked, Honorable Daniels, not a separate from another council.
All right, thank you, because let's not forget, it's all it is, it's an opinion. Thank you.
All right. Thanks very much. I now invite Advocate Mkari SC to brief the committee on the legal opinion.
Thank you, Chairperson, and members of the committee. Let me clarify from the beginning the issue about the first opinion and the second opinion. There is only one opinion. The first was a draft which I provided to the state attorney to provide to the chairperson so that the chairperson can share with members of the committee. As I was told that there will be this meeting at 8 o'clock, and if I were to wait to finalize the opinion by cleaning it up, then by the time the opinion is sent, it will be in the middle of the night and everybody will be asleep. You'll only be confronted with an opinion just a few minutes before the meeting starts. But the conclusion reached was definitive and final. What remained was for me and my members to look at the language, clean it up, and to remove a certain unnecessary repetitive things which, in my view, were not necessary for purposes of you understanding the import of the opinion and what we seek to communicate to you. And it was to make sure that it is in lucid and simple form. So the opinion that has been provided as a final opinion is the one that was sent this morning, which does not differ at all from the draft, except that I was cleaning it up so that it looks more clean and logical and simple. I'm going to not regurgitate it as you already have it, but it is to, at a high level, give the synopsis of what, in essence, we've come to conclude. We are saying to the committee, you have two options to the interdict application. The first option is to oppose the urgent application, the interdict. But you do have the second option. The second option is to file an explanatory affidavit to the court in order to assist the court with your legal understanding of your duties arising from the Constitutional Court judgment. But we're of the view that the first option is the more appropriate and preferable one, because you'll be able to assert what you understand to be your duties and obligations arising from the Constitutional Court judgment. But we do caution you to say that you mustn't forget that as the impeachment committee, you were appointed to be independent and impartial. You, at this stage, have not formulated a view on the merits or demerits of the impeachment itself. You have not had an opportunity to assess the evidence or call for evidence. So you still exercise that independence which will enable you in the process to gather the evidence freely and without any interference. So it will not be appropriate at this stage for yourselves as a committee to express a view or an opinion as to the merits or demerits of the impeachment process. But what you are, however, entitled to do as a committee, independent as you are, is to assert that which the Constitutional Court has enjoined you to do. We say that in paragraph 7 of the order of the Constitutional Court, it has specifically stated that the impeachment committee should ensure that the report of the independent panel is given effect to, and that can only be through the impeachment process. We understand that order to be from the apex court, and it is an order that must be given effect to. Of course, we do appreciate that the president has a right to approach court and to ask for whatever relief he wants. But that does not detract from the obligation imposed already on this committee by the Constitutional Court to proceed to do its work. So this committee will therefore not be acting inappropriately if it decides to oppose the interdict application purely on legal grounds, simply asserting what its duty has been as mandated by the Constitutional Court. And when we say that purely on legal grounds, it is purely on the proper interpretation of the judgment of the Constitutional Court, which requires that an impeachment process must commence without delay, expeditiously, in order to bring finality to this important matter which involves the President of the Republic. So that is really what the committee will be saying to the High Court. The other legal ground that were flagged, which we think in our view should merit attention by the court when it hears the interdict application, is whether it is legally appropriate and permissible for the High Court to stay or interdict the duty that already has been imposed by the Constitutional Court for the impeachment process to proceed. Our view is that the High Court is in no position to do that because the order is already that of the apex court, and only the apex court can stay its own order. And we have the view that this is a point that the committee is well positioned then to put to the court when the interdict is sought. But also importantly is whether the committee continuing with the work will prejudice the president, held before court by the president, is that it seems to us that all what the committee is required to do is to gather evidence and evaluate it. Those who have the evidence will be called by the committee. They'll be scrutinized. Their evidence will be scrutinized. The president will have an opportunity to controvert that evidence and also adduce his own evidence. So that way, then the president's rights are not imperiled. In fact, it is at that point that he will have an opportunity to put the matter to rest by demonstrating through admissible and credible evidence that the allegations or evidence placed before the committee is of no moment and ought to be rejected. So that we say alleviate whatever prejudice or irreparable harm that the president say that he is going to suffer. And that is another important point that the court will consider, because the court will not interdict the committee if it is satisfied that the committee will give the president a fair hearing and will give the president a fair opportunity to controvert the evidence or allegations that would have been placed before it by whoever would have been called by the committee. So it is on that basis that we say that the committee is capable legally on the facts of this matter and given its position to oppose without it being perceived to be biased or to have prejudged the matter of impeachment. So that is really then in essence what we are advising to the committee. So based on this analysis, based on the facts, and based on the law that we have relied on in the opinion, we say that the committee is better positioned now to take a decision as to whether it takes the route of opposing or whether it takes the route of putting an explanatory affidavit. But the end result to us comes to one point, that is, either way, the committee should participate, because its participation will simply or will enrich the court, especially on the legal issues that will be debated or which have arisen or arise in the litigation itself. So that is the summary of the opinion that we have provided to the committee. You have noticed in the interdict application that the chairperson is cited. The committee is not cited. In case then the question will arise, then let me answer it already up front. It was not necessary for the president to cite all members of the committee or the committee. The chairperson is a nominee officio of the committee and acts in his official and representative capacity on behalf of the committee. So when the president has cited the chairperson of the committee, he has cited the committee. So it is the committee that is cited. So you don't have to worry about the nomenclature that it is chairperson that is cited. Thank you, Chairperson. Back to you.
Thank you very much, Advocate. I don't know, Suan, if there's anything you want to add before I invite members for clarity seeking questions.
Chairperson, no, I'm fine, thank you.
All right, thanks very much, Suan. I'll now invite members for questions. Once we are done with the questions, we'll now go to debate or discuss the opinion with a view of taking a position as a committee. I will start with Honorable Swart, and then I'll come to Dagmar.
Chair, thank you very much, and I hope you can hear me. But I have a question of clarity, and I wanted to ask the senior counsel, and firstly, thank you for the opinion. If the interdict is granted, would it hold for appeals of the review application? Should any party be upset with the outcome of the review application and want to appeal to the Constitutional Court, would the interdict be open-ended until that Constitutional Court appeal is heard? In other words, how long would it be in operation? Thank you.
Honorable Dagmar.
Thanks again, Chairperson, and thanks very much to Advocate Mokari and the team. Just to link up to the point that I had raised earlier, if one looks at what we are now referring to as the first opinion, although as Advocate Mokari is saying there's one opinion, but in that first opinion under clause 12, and I want to quote, it says, the IC should actively oppose the urgent interdict application and file notice in the review application. Now, I'm then trying to find the equivalent of that clause 12 in the in the second opinion that was provided to us. And then when you go to that particular clause in the second opinion, it's got just above it the little Roman 2, which is the headline, why is it appropriate? And then basically that whole clause, is different. So what I would like to ask Advocate Mokari is that, was that a mistake in the initial opinion? Because I don't understand that the impeachment committee is has been cited in the review application, if I'm not mistaken. We're talking here about the interdict. But in the opinion, which I read out, it then the approach basically is oppose and then file an application to abide by the review application. So I just wanted clarity as to, what was that a mistake in the first opinion? Because what I understand from the summary that you've given us to the Chair Advocate is that you're saying your advice, for the reasons you've outlined, is that the impeachment committee opposes the interdict. There is, you say, a second application that we can file. I think you said an explanatory affidavit, but your view is that the impeachment committee should oppose. That I understand clearly. And then my last issue: if one opposes, can one nevertheless still file an explanatory affidavit? So that's the clarity, and I think that's the confusion that I picked up this morning in terms of, and I understand what you've explained, that you provided something last night to the committee, which you refer to as a draft. But could you just clarify that? Thank you so much.
Thanks very much, Honorable Dagmo. Honorable Maimani.
Thank you, Chairperson, and or as I should refer to, comrades, Chairperson. Chairperson, a few questions that arise for me. The first is the question that is put in the legal opinion about whether or not a lower court could oppose a higher court. And so what I'm trying to understand is whether or not it would not be in the interest of the committee to seek a declarator from the Constitutional Court on this matter, apropos the comment that is made by Honorable Swart as to what levels are these matters then open for review, or as judgments are being handed, who can appeal, etc. How do we go about that particular process? The second question of clarity for me, Chairperson, is political parties have already themselves filed a notice to oppose. And therefore, in that light, I want to understand how the committee then, in one level, were we to take a view that says we take one decision, yet political parties that have been cited by the president in the application took a different view. How is that in operation in terms of the committee and where its functioning goes? And then if I could ask that, what I didn't see, and maybe I might have missed it, was the agreed timeline that was put forward. Because in the legal opinion, it states that the committee's work is inquisitorial and not in this sense that it can hear its own evidence, etc. Given the timeline that is being put forward, and that the legal opinion states that the question of material harm, where an interdict not to be granted, does not arise given the mandate that has been given to the committee. I asked this question, Chairperson, that the committee has already been served with the reports. What would be then, if you like, if the interdict was not granted, what would be the procedure post the timeline that's been set? What would happen if the committee was to continue with its work and simply make it clear that it is complying with the Constitutional Court? What impact would that have? So my questions are threefold in that regard. The declarator question on the Concord, so that we avoid this delay of appeal, etc. Secondly, the political parties that have been cited, and of course, naturally, if the senior counsel states quite categorically that the committee is thus enjoined by the person of the chairperson. If I hope I'm not using incorrect language, but what I'm trying to also allude to is that each of us serving on this committee represent particular political parties. So what would happen if those parties then chose a view contrary to that of the committee, whether to oppose or to abide? And then lastly, that question that then sits, what would be the material? Because I think in enforcing the Constitutional Court judgment, the committee could feel it is acting in its own interests. What would be the impact of that action where it be to be proceeded with? Thank you, Chairperson.
Thank you very much, Honorable Maimane. Before I go to Honorable Trolip, there's Mr. S. iPad. I don't know who that is. If you can just identify yourself.
Thank you, Chair. My name is Julius Malema.
All right. So, thank you, Honorable.
I will ask these fellows to amend this thing. I don't know how to do it. Thank you very much, and congratulations on your Comrade Marathon. And thanks for calling this meeting urgently. And I also want to thank the SC and the collective.
I'll come to you, Honorable Malema. I just wanted it to be identified. You are on the list.
Okay.
I'll come to. Okay. I'm going to Honorable Trolip now, and then Zungula, Ngola, and then I'll come to you, Honorable Malema. Honorable Trolip.
Thank you, Chair. I have no questions of clarity. I'd like to use this opportunity or my opportunity when the time comes for comment. Thank you very much.
Thank you very much, Honorable Trolip. Honorable Zungula.
Morning, Chair. Morning to the colleagues and morning to the team, legal team that assisted the process. And firstly, congratulations, Chair. My question of clarity. Firstly, it's about the role of the committee when it comes to defending Parliament and advancing the interests of Parliament in this particular litigation. Is it the advice of the legal team that the institution, which is Parliament, ordinarily you would find the Speaker acting on behalf of Parliament when it comes to litigation? Is it your opinion or your advice that has now been delegated to this particular committee, and the work or the defense that will be done by this committee will be, in effect, a view of the entire institution, which is Parliament? That is the first issue. The second issue, it is what you had stated in your presentation, that your view is that the court order is coming from the Apex Court, and no high court can overturn the order of the Apex Court in this particular interdict process. Now, when the Apex Court gave the judgment on the Pala matter, they also dealt with the processes of Parliament, which then led to the independent panel report. Would it your opinion as well that also on the review application, the review application basically wants to overturn the outcome which was ventilated in the Concord? Is it also your opinion, therefore, that this committee should continue to defend the work of Parliament, particularly in how the process was run and the outcome of the process? I do get your view that the process, the committee has not yet established its view because it is still to work, call witnesses, etc. But the committee should be viewed or understood as a committee that needs to support the work of Parliament, the processes of Parliament. And as it stands now, that independent panel report, which comes from the processes of Parliament, which there is no committee of Parliament, no legal opinion internal in Parliament, no structure or formation in Parliament which has found that there is something wrong or unlawful in the independent panel report. Would it then be opinion that we also need, the committee would then need to defend that particular report as it comes from the processes of Parliament, which internally has not been found to be unlawful or legally unsound? Thank you.
Thanks very much, Honorable Zungula. I've just received a request from the broadcasters to say if you are able to switch on the camera, if your bandwidth allows, please do switch on the camera. It does help with the broadcasting. So that's the request that I've just received. I'll now go to Honorable Nola.
Thank you very much, Chair, and apologies, Chair. I'm in the villages busy with elections work, so my bandwidth won't allow me to switch on my camera. Apologies for that. And also, Chair, I think let me join my colleagues for congratulating you on the sterling work that you have done in the Comrades Marathon. You are inspiring all of us. Maybe next time it will be me and Honorable Malema in the Comrades Marathon. Chair, just two quick issues. One, how is it legally possible that we file an opposition to the interdict application without touching to the merits of the Section 89 panel report, which has not yet been formally tabled before this committee, and touching on the merits of the review application, that which we are not part of? That's the first question, Chair. The second question is, am I correct to think that what we are trying to do is a response to an interdict application that has cited the chairperson of the impeachment committee? So whatever view that we have still does not bind the other parties that have been cited in the interdict application. Mr. Zungula can still find his own appropriate action. The EFF can still find its own appropriate action. And the ATM, which are cited in the interdict application, they can still, outside what we are trying to do as the impeachment committee, they can still find their own appropriate action into the interdict application, while also really confining ourselves to the fact that the chairperson of the impeachment committee has been cited in the interdict application. I just want to check if my understanding is proper in respect of that particular aspect. Thank you.
Thanks very much, Honorable Nola. Honorable Malema.
Thank you very much, Chairperson, and once more, congratulations for Comrade Marathon. Honorable Nola is right. Check out next year. Will be part of you running Comrade Marathon. And also thank you for convening this meeting. I just want to provide one clarity so that we don't act like we are confused when we are not. There's no second opinion. Anyone who says there's a second opinion is deliberately trying to mislead the nation and this committee. The SC put it very clear. If you have dealt with lawyers before, or you have exposed yourself to how lawyers operate, you will know that there is what we call first draft, second draft, and then final draft. And the SC explains very well that it was an agent matter to an extent that if I were to work on minute detail of everything, you are going to receive it at 12 midnight. I had to work on what I worked on and submit for you so that you can have something to work on while I'm still working on the final opinion. I'm on a final draft. So there's no second opinion. get that into your head. There's no second opinion. There's one opinion which had first draft, and now we're dealing with first draft. Pay attention to the final draft. That's how it works. So we should, all of us, have that kind of an understanding. Having said that, I want to ask the SC if whether we should not also argue the question of jurisdiction. Because I don't think the Western Cape High Court has got the jurisdiction whether we're proceeding or not. The Constitutional Court has given that directive. And no lower court can actually entertain anything that seeks to stop this process except the Constitutional Court itself. So before we even go anywhere, I'm of a view, and the SC will clarify me on that one. I have a view that they've got no jurisdiction on the proceedings or not proceedings of this committee. And therefore, that point on arguing the jurisdiction is going to be very important and very fundamental to remind the Western Cape High Court that it has got no leg, none whatsoever, to deal with this matter. A directive, like you said, SC, comes from the Constitutional Court. And therefore, we should confine ourselves to the jurisdiction, but equally that they're not competent to deal with whether this committee can go on or not. The chairperson is a chairperson of a committee, and understands that the chairperson is cited by virtue of being a chairperson of this committee. Therefore, they are citing the committee. To suggest anything that the chairperson is being cited because he's a headman of a village, it's incorrect. If he was there in his village minding his own business, he was not going to be cited. He is cited because he's our chairperson. And through him, they are citing this committee. And therefore, we are duty-bound to respond as to it. We'll deal with the merits when we deal with other issues, Chair, as to how we proceed. Thanks.
Thanks very much, Honorable Malema. Honorable Mutambi.
Thank you, Chairperson. And then you'll pardon me also, my bandwidth is terrible where I am. Just to join the colleagues who have congratulated you and also to welcome the opinion as presented to us by Senior Counsel. The issue that I want clarity on is on paragraph 8 of the opinion. I think this is the question that was also been raised by Honorable Sungula, this issue of the IC being an organ of state. Then to also say, then does it divorce? Is it from the speaker also is cited as the first respondent? That's the issue that I want clarity on. The other one is on paragraph 18 of the opinion itself. Towards the end of paragraph 18, the opinion says that this order, the order of the Concord is final and no order of the High Court may completely displace the Constitutional Court order. I just want the Senior Counsel to expand what does it mean. Does it mean that this interdict, as it's made before the court, is misplayed? And then the last one on paragraph 44, the Senior Counsel has given us options. 43, that the IC should oppose. Also, if the IC decide not to oppose the agenda application, it must file an explanatory affidavit which will assist the court in the adjudication of the matter. So maybe the opinion should have gone further to explain those instances, what kind of items must be put on that explanatory affidavit. The other issue that I want also the Senior Counsel to also explain in line with that paragraph 44. We have been informed that this interdict is going to be held on the 15th to the 16th of July 2026. And then at the same time, the committee is still busy with its own preparatory work. Maybe this work can go up to end of August, and then under the circumstances, Are these some of the things that the explanatory affidavit has referred to on paragraph 44 can also consider to be put there? Those are the issues that I wanted to raise, Chair. Thank you for the opportunity.
Thank very much, Honorable Mutambi. Honorable Mahlatsi.
No, thank you very much, Chairperson, and congratulations and greetings to the colleague, greetings to the legal team, and I would also like to welcome the opinion. Chairperson, please accept my apology. I'm not in the right space also. I'm in the car. And now I just want to go back to the opinion on the the overstatement of the High Court jurisdictional limitations. The opinion argued that the High Court lacks jurisdiction because an interdict will effectively suspend the constitutional court order. While persuasive, this argument is not beyond dispute. My opinion is that the President may argue that he is not challenging the constitutional court order itself. He is challenging the legality of the underlying report. The interdict merely perceive the status quo pending review. A court may distinguish between suspending a constitutional court order and temporarily regulating the consequences flowing from that order. So therefore, the jurisdictional argument, it is not absolute as an opinion suggests. That's my opinion. And also, the opinion largely focus on constitutional obligations, but give limited consideration to procedural fairness, or the alteram patent rights, and the potential prejudice arising from reliance on the Ngobo report. I think the President's review may raise administrative law concerns that deserve full treatment. I would like if maybe they can put attention to that. Chairperson, I submit.
Thanks very much, Honorable Mahlatsi. Honorable Kwankwa.
Thank you, Chair. Same problem. Thank you. Chair, I feel like I understand and I follow entirely the legal opinion given by the senior counsel. And I think our conundrum has been created by the fact that you were cited and the committee was cited. But I do feel like the President's strategy is a bit sending us on a wild goose chase, where we have to challenge the matter in our own right, when in fact the committee derives its mandate exclusively from the National Assembly and possesses no independent authority or legal standing of its own. Now, should the right process then not have been to, as Zungula was stating earlier, or Honorable Zungula, since we lack that independent status, and I don't think it's legally permissible for the committee to issue a response on its own. I understand that we're given advice on the basis of it's a response to the President's legal strategy. But would it not make sense? Because if we have delegated powers, we can only exercise those powers which are delegated to us by the National Assembly since we are formed in terms of that and in terms of the rules of Parliament. And since we do not have any inherent powers as a committee, right, to be able to exercise that. The strategy, obviously, the decision is, yes, we have to challenge whatever the President is throwing our way, but which one is the most legally permissible way of doing it? Is it not doing it via the National Assembly, via the Speaker's office as per usual? I personally, I could be wrong, that the President should have interdicted Parliament and not necessarily cited you per se, and had Parliament deal with that process, because it's a parliamentary process. The committee is not a standalone what. It doesn't have its own, it has no inherent powers, for example, to be able to exercise insofar as this matter is concerned. I would like to hear the views of the SC on that matter. Thank you kindly.
Thanks very much. Honorable Breitenbach, Advocate.
Thanks, Chair. Good morning. Chair, yes, I agree with the previous honourable member. I don't believe that the committee itself has any locus standi, and the opposition to the interdict will have to be done via the Speaker. But that we must lobby the Speaker to seriously oppose it is so. We cannot allow it to just go through the process, and we can't just be casual bystanders. So we must lobby the Speaker to vigorously oppose the application, and until an interdict is granted, if it's granted, because there's nothing to suggest that it will necessarily be granted, we must carry on with our work. Thank you, Chair.
Thanks very much, Honorable Breitenbach. That concludes the hands on this round of questions. I'll now ask Advocate Bukhari to just offer responses to the questions that have been asked by honorable members. Advocate Bukhari, SC.
Thank you, Chairperson. I will respond to the questions in the sequence by which they were raised, starting with the question from Honorable Swart, whether the interdict would have the effect of indefinitely postponing the commencement of the impeachment process until the appeal processes are finalized. The current request from the President from the papers is limited to pending the review application. But in law and in practice, let's say the review is successful, and one party then wishes to take that order on appeal, then it will extend that interdict or suspension going forward. So yes, Honorable Swart, you're correct that whilst the request as it stands in the court papers is limited to the outcome of the review, but appeal processes are likely to extend that fight and suspending the commencement process of the impeachment until all appeal processes are finalized. But that is entirely dependent on what type of an order has been received from the review court. If the review court, for example, is to dismiss the application of the President, and the President wishes to appeal further, then the appeal against the dismissal order will not necessarily resuscitate that interdict, but the President will still be able to approach court and say that because I'm appealing, I want the interdict to be extended further, and that can always be done. So the long and short of it is that, yes, the possibility is that once this litigation is commenced and the interdict is granted, the committee's work may remain hamstrung until all appeal processes are finalized. Coming to the question from Honorable Dagmo, that has been eloquently answered by Honorable Malema, and I've also mentioned it, that the first was a draft, and the final opinion is the one that we are working on. And of course, Honorable Dagmo, you referred to certain paragraphs which are no longer in the final opinion. That is how drafting is about, that you remove those aspects which are not relevant now for purposes of delivering a final document. So we have only one opinion. Then coming to There's another question that you also asked, the second one, about the filing of the explanatory affidavit, that you are not clear about whether it is the explanatory affidavit in the same interdict application or in the review. We have not expressed an opinion on the review because the committee is not cited in the review. If the committee will want to participate in the review, it will require its intervention through the processes of intervention provided in the rules of court. But at the moment, the committee is not cited in the review. That's why we did not express an opinion on the review itself. So the explanatory affidavit we are talking about as an option available to the committee is the explanatory affidavit in the interdict application. And that explanatory affidavit will simply be there to assist the court. So what you are asking the court is to say that whilst we have decided not to oppose, there are matters of significance or importance which we would nevertheless would like to bring to the attention of the court so that it assists the court in the adjudication of the matter. So that is what the explanatory affidavit will be dealing with. But if you are opposing, you are putting a clear position of the committee as to the committee's understanding of its obligations as imposed on it by the Constitutional Court judgment. So that is really then the distinction. Coming to Honorable Maimani's question, whether the committee could approach the Constitutional Court for declaratory order. Well, the committee, and when I answer this question from Honorable Maimani, it will also answer the question that was asked later by the other members, but I'll still come to them so that I also pay attention to their questions. The committee, once it was established to perform a particular function, and it is a constitutional function that it is called upon to perform. It can only perform that function properly and adequately if it is independent and impartial. So this committee is an independent committee. It's not an appendage of any other structure or parliament. Members of the committee are members of parliament, are members of the National Assembly, but for present purposes, they are members of an independent committee which takes its own independent decisions which have legal effect and legal consequences. So that's very important. So this committee can do anything legally permissible, including seeking clarity from the court on any aspect without varying the speaker or parliament. But to go that route will be to overburden the committee with matters of litigation when its object is to ensure that it processes the impeachment in terms of its mandate. So it should not deviate from its mandate. Its core mandate is to ensure that the impeachment process is underway. Those who want clarity as to what is the import of the Constitutional Court order, because then it impacts on them, they are the ones who must go and seek clarity about whether they want a declarator or not. But that question will also be indirectly or directly answered in the urgent application, which is coming next month, because the court will have to deal with that particular issue. So, Honorable Maimani, it may even no longer be a matter of concern as to whether a declarator is to be sought or not, because that issue may very well be answered in the urgent application. With regard to political parties taking their own decisions, either to participate in the interdict application or not to participate, that is entirely upon the political parties themselves. And whatever decision they've taken does not at all affect any decision that is taken by the committee. This committee, which is constituted by members from different political parties, because once they are members of this committee, they are members of the committee executing their duties in terms of their mandate of the committee. So there will be nothing at odds or untoward if, for example, a political party that is represented in this committee takes a decision to participate in the litigation, but the committee takes a decision not to participate. There is nothing contradictory there at all, because the political party is taking its own decisions according to its own policies, rules, and so on, whereas the committee is also taking its own decisions according to its own mandate and its own understanding of its role. So there should be no conflict at all or no confusion that the political party A has taken this decision, but its member in the committee has voted for something which contradicts that political party's decision. So there should be no contradiction there. So the mandate of the committee and the procedures, of course, then the committee is still at the very early stages. It is still trying to put systems in place. And so it is work in progress. So we cannot at this stage talk about what procedure or whatever, but whatever procedure it will adopt, it must be a procedure that is fair, a procedure that will enable it to execute its duties in a manner that it is able to come out with an outcome that it can present to the National Assembly for consideration. So fairness is the overriding concept that will always reign in whatever the committee will be doing. Then coming to the question from Honorable Malema, Honorable Malema then raised whether the issue of jurisdiction should not be raised. In fact, then that is the very point that we have flagged already in paragraph 18 of the opinion, that this is an issue that, in our view, is significant, because we looked at the judgment of the Constitutional Court, we looked at the order that is unambiguous, especially paragraph 7 of the order, and we say that if one looks at that, it really puts into question whether the High Court will have even the jurisdiction and power to grant the type of an order that is sought. And we say that the committee is actually better positioned to put forward that legal proposition. Of course, it has to be debated, because then later on there was one member who said that he doubts if that point is absolute. It's not absolute, but is an important legal point which arises direct from the order of the Constitutional Court. And it has to be considered, of course, by the court. It is not absolute, but it's an important legal point. So that's a point that we're making. So it's a point that you cannot ignore, and it's a point that even the court cannot ignore. Honorable Trollip, of course, then said that then he is reserving, then he had no questions. Honorable Zungula asked about the role of the committee, given that the committee has been established then by Parliament, whether the committee represents the Parliament. Well, of course, this is the committee of Parliament in a sense that we know that it was established by the Speaker, and the Speaker was enjoined by the Constitutional Court to establish this committee so that it can perform its duties, and those duties must be performed independently and impartially. So once that committee is established, it has its own chairperson, it regulates its own processes, and it can even have its own rules which will regulate it for the period or the duration of its existence. So it is not a committee that must time and again go back to the Speaker and say, Speaker, are we allowed to do this? Speaker, are we allowed to do that? Then such a committee then is not independent. But this one was created purely to be independent, impartial, and perform its duties without any interference or influence by anyone, including the Speaker. So what it means is that it can take its own independent decision whether it wants to participate in the litigation and oppose or not without any view from the Speaker. So there is nothing wrong if the Speaker and the committee take contradictory or opposite views regarding the matter itself. For instance, the Speaker saying that, well, I'm going to abide. It doesn't mean that that decision of the Speaker binds the committee, because the committee is cited there and it must take its own decision as to whether it abides or whether it opposes. So the role of the committee must always be properly understood as the role that is independent and enables you as members of the committee to take your own decisions. Then coming to Honorable Ngula, whether is it legally possible to oppose without dealing with the merits? Yes, of course you can, because the committee is opposing on legal grounds, and those legal grounds were flagged them in the opinion, and we of the view that those will be sound legal grounds to be considered by the court and to be put forward by the committee. And it can do so without entering into the merits, because why do you want to enter into the merits at this stage when you have not even applied yourself to the merits? Remember, at this moment, you are still putting systems in place in order to give effect to the mandate given to you then by the Constitutional Court that you must actually process the impeachment. And that's really what you're doing at the moment. So why will you want to enter into the merits at this stage? So I don't think that even at this stage you are even able to formulate any view, because it is too early in the process for you to formulate any view in that regard. But you can still oppose, and you can oppose on legal grounds. So there is nothing that prevents you. And I've already answered the question about political parties, that they can take their own decisions, and those decisions then will not bind their members in the committee. The committee can take its own decisions. And coming to the question from Honorable Mutambi, whether then the committee is an organ of state and whether it can... So I've already answered that question to say that once it is established to perform a constitutional function or duty, then it is akin to an organ of state. When we say it is akin to an organ of state, it's not an organ of state per se, but it is akin to an organ of state because decisions that it takes are decisions that impact on persons one way or the other, and those decisions can be challenged. Exactly then the same thing with that independent panel which the president is reviewing its report. That was a panel of external persons who are not members of the National Assembly or Parliament, but because they were appointed in terms of legislation, in terms of the Constitution, to perform a constitutional duty, they were akin to an organ of state, and their decisions are now taken on review by the president, because he says that whatever decision they took has had direct external effect to him. So it's the same thing also with the committee, that once you are established, you are akin to an organ of state, and you take decisions that may impact one or the other on persons. And of course, you've already referred to paragraph 18 of the opinion. It deals with jurisdiction, and we say that that is a point that has to be taken, or is a point available to be taken by the committee to the court, because we believe that it is a good point. It is not an absolute point, but it is a good point, and it's a point that indeed that can have a proper consideration and may find favor with the court, especially when the committee is relying on the constitutional court order, which we say that is an order of the apex court, and there is no court which can displace the order that has been made by the constitutional court. Regarding paragraph 44, of course, then that's where we have an option of the explanatory affidavit, and I've already dealt with that issue as to the import of an explanatory affidavit and what it will seek to achieve. But that becomes relevant only if the committee decides not to oppose. It must nevertheless participate one way or the other. Then to the question by Honorable Mahlatsi, of course, then I've already answered that question. He was asking whether, well, to say that jurisdiction argument is not absolute. Yes, it's not absolute, but it is arguable and is persuasive. Of course, you say that what matters is procedural fairness. Indeed, the committee will ensure that it is fair in its processes. It will ensure that it doesn't simply look at the documents and make decisions based on documents alone. It will ensure that it invites those people who can assist it with evidence or adduce proof to substantiate certain things to come before it and justify the allegations that they make. And it will also give the president an opportunity to respond to those allegations. And that is exactly what we call procedural fairness, because procedural fairness then boils down to audio altera partem, to say that hear the other person, don't make decisions before you hear the other person. So you're going to be doing exactly that. And that's what fairness is about. And that procedural fairness is going to obviate whatever prejudice that the president says that he's likely to suffer. Because if you're going to be given opportunity to demolish whatever evidence people were bringing against you, then you have actually removed whatever prejudice, because now you have demonstrated to the committee that all what these things were being said were just hogwash and they have no merit, and you have produced evidence, you've shown the committee all the facts, and the committee looks at it, and the committee is happy with that, and the committee then will dismiss the whole thing and say that, look, there is no basis then for Parliament to impeach the president. So that is what the president will get. And that's what we mean when we say that we don't see any potential prejudice or irreparable harm that the president will suffer. So it is in that context that we reach our opinion. Then coming to Honorable Nkwankwa. Honorable Nkwankwa, then you have the power as a committee to do all sorts of things that have the potential to impact on other people, especially in this case, of course, it is the president. So that is power. So, and you are given this mandate to do this without fear, favor, or prejudice. That is independence. So you mustn't think that you're not independent, that you are relying on the parliament and speaker. You're not. You are given this power. And it's a power that you have to exercise constitutionally, procedurally fairly, and within the bounds of your mandate. So that is power. So the committee has the power to do all those things. And to Honorable Breitenbach, of course, then it was a question of saying that the committee does not have local standing. Remember that the committee has not brought any matter to court, and it has not indicated that it wants to bring any matter to court. So the issue of local standing doesn't arise. Remember that local standing arises only when you go to court, because you must prove that you are entitled to go to court and ask the court for what you say you want. You are entitled to ask the court to give you what you want. That's where the local standing thing comes. The local standing thing doesn't arise when somebody then invites you to court as a respondent and say that answer. How can you call somebody, you say answer, then when that person answers, you say that this person does not have local standing? It's absurd. So the committee has been cited through the chairperson, and therefore it is entitled to answer if it wants to answer. And nobody will say that, show us your local standing, because the committee is invited to answer if it wants to. So the only decision it has to make is, can we answer or not? Can we participate or not? So that's the only decision that it has to make. But so then it does not have to grapple with whether it has local standing, because the local standing issue simply does not arise. And when I check my notes, it seems as if an Honorable Breitenbach's question was the last question. Thank you very much, Chair.
Thanks very much, Advocate. Is there any member that wants to do a follow-up before we go into the discussion? Are these hands for follow-ups or are the hands for discussion? If your hand is for discussion, please put it down. I only want the ones on follow-ups. Honorable Zungulo on a follow-up and Honorable Dagmo. After these two, we'll then move into discussion. And also, as you discuss, indicate the direction that you believe the committee needs to take. Thanks very much. Honorable Zungula.
Thank you, Chair. It's not really even a follow-up. It's to highlight a question that was not answered. The question that was not answered, I asked the opinion on the committee participating in the review, notwithstanding that we've not been cited, but we are an interested party, because the review on the application to review the independent panel, greatly impacts the work of this particular committee. I know the SC spoke about the issue that we've not formed an opinion yet, but the opinion whether to impeach or not impeach is the last of the process. Where we are now is that independent panel report, which the President has filed to review on the 2nd and 3rd of September. It is through an outcome of the National Assembly, which has not, through our internal processes of Parliament, been found to be unlawful. Therefore, the question I wanted to check from the SC, whether, based on the advice that we oppose the interdict, should also not the advice that we also oppose as a committee or the National Assembly also oppose then the review application, because that review application seeks to set aside a report that is from the outcome of a process of Parliament or the National Assembly, which in our own internal processes, we have not found that there's something amiss. So that is the question that has not been answered. Thank you.
Thanks very much, Honorable Dagmo.
Thanks again, Chair. Chair, my point is a point related to where we are in the process and the need to clarify something, because it would appear that people who are not either part of the committee WhatsApp group or don't read what's in the WhatsApp group. And this is an issue which I really appeal to you, Chair. to take this up. We received what was described as an opinion, not a draft. It was described as an opinion at 6 o'clock this morning. And then when we were then informed of another opinion and asked whether, what was the reason for that, we were simply told that there were grammatical errors. And I really want to appeal that this needs to be resolved, not only the issue of providing information earlier, but also, not to bring members of the committee. All of us understand that there's one opinion, and that has been clarified. But it's important for everyone here to note that the response we were given was that there were grammatical errors or changes, and clearly there were content changes. So I'm not disputing and I'm accepting there's one opinion, but when information is given to this committee late, secondly, when there is wrong information provided to the committee, that creates the situation. And I would advise that that we follow, all members follow what's going on in the group and would understand why the process of the process. No, let me finish, Chair. I'm about to conclude. I want to make that point very strongly, because otherwise impressions are created to the public and others about a process which is not correct. And I appeal that we sort this out and manage ourselves better. Thank you.
Thank you. So there was no follow-up question there. Honorable Daniels, on the follow-up question.
Thank you, Honorable Chairperson. Honorable Chairperson, I think it's really important that we indulge one another with the purest objective to understand what we are saying. That we not stifle each other and not tell someone how to respond and how to express themselves when they are seeking clarity. Because, we've just started with this committee, and I can see that I'm trying to avoid it becoming a problem going forward. Clarity-seeking questions must be appreciated, Honorable Chairperson. As was the question whether the legal opinion were from the same legal firm or not. Because what I've heard was there could have been more than one legal firm, and therefore the question was asked. Now, even with all the experience from dealing with lawyers and being an expert on draft legal opinions, I wouldn't risk lecturing anyone on best legal modalities, considering that this newfound lecturer has recently been found guilty, and that wasn't a draft guilt verdict.
No, Chair.
It was declaring the newfound lecturer a convicted criminal. I can't take advice from such a self-made lecturer.
Honorable Daniel.
No.
I can't take advice from such mid-lecturers, Chairperson. We must respect each other.
Honorable Daniel.
Honestly, we can't be
Daniels, you are not following what I asked. This section.
Honorable Mautwe, Daniels is a fool. He's a stupid. It's not worth entertaining.
Honorable Malema, please. Honorable Malema, you can't say it. Please.
I can't be lectured by someone about how to approach the legal.
You are a fool. You are a fool. You are a stupid. That's what you must know. You are a fool.
Yeah.
Honorable Daniels and Honorable Malema, please.
You are a stupid.
I must be advised by someone who's just been convicted.
You are a stupid. You are a fool. Even where you come from, they know you are a fool.
I must interpret legal opinions.
You are inherently a fool. You are incompetent and illiterate.
Can I ask the technical team to mute Honorable Daniels and Honorable Malema for now, please? Let's not. The meeting has been progressing well. Let's not get into matters that are not for clarity and also not on the opinion. Honorable Daniels, it's my appeal to you. Do you have a follow-up question to the responses that have been given?
He doesn't have. Please, let's move. He doesn't have. He's just
Honorable Maut, I haven't recognized you. Please. Thank you. Honorable Director.
Chairperson.
Thank you, Chair. Greetings to the members. Chair, I've got a follow-up I've heard what the senior counsel said regarding the National Assembly, but I need further clarity as to what then becomes the relationship between the National Assembly and the committee if the two were to adopt a different positions on this matter. How should such situation be handled? My concern is that committees are not independent of Parliament. They derive their authority from the National Assembly and act on its behalf. In those circumstances, can a committee legitimately take a position that differ from the National Assembly? And if so, what would be the constitutional or the procedural implication on the matter? Thank you, Chair.
Thanks very much, honorable members. Honorable Director, I just want to appeal members that let's focus on the task at hand, and let's not get into personal insults and just get to do what South Africans have asked us to do on this very important committee. I will now invite Advocate Mkhari to respond to the two follow-up questions, one from Honorable Zungula and the other one from Honorable Director, and then we'll get into discussion. Thanks.
Thank you, Chairperson. I apologize to Honorable Zungula. Indeed, you asked that question and I didn't answer it pointedly about whether the committee can participate in the review. Yes, of course, as I've already indicated, that the committee is not cited as a party in the review or as the respondent. It is on that basis that we didn't really express a view on it. But to your question as to whether it can participate, yes, nothing will stop the committee, if it so decide, to intervene in that application, that is the review application, but to deal with the issues that you have highlighted, such as to show that the processes that were followed were procedurally correct and above board without prejudging any matters in the review which touch on that which the committee is still to investigate and express a view on it. So then, yes, the answer is the committee can, in terms of the rules of court, intervene at any stage that it deems appropriate, that it can participate in order to put certain matters to court which are necessary for the court to take into account before it takes a decision. Of course, then with regard to the other members, it's fine. Then to Honorable Direko, is about, again, the committee not being separate. Well, the committee is a committee. It is established by the National Assembly process and it exists. Once it exists, then the committee must perform its functions. And of course, it is not divorced from the Parliament. Absolutely, it's not an absolute thing. Here I'm talking about insofar as this litigation is concerned. So it must be very clear. It is insofar as this litigation is concerned. I'm saying that this committee is independent and can take its own independent decision as to whether it participate or not. It does not require permission from the Speaker. That's the point that I'm making. I'm not talking about other matters where the committee may require the consent of the Speaker, concurrence of the Speaker, or any other process that is relevant for the synergy that exists between the Speaker and the committees that are established to perform an ad hoc function, that is a function that is time-bound like this one. So I'm not talking about such situations. Such situations may be there, and they will fall under the situation that you are highlighting, Honorable Direko. But this situation where the litigation is pending, the committee is cited, then the committee is entitled to take its own independent decision about whether to participate or not. I thank you. Back to you, Chair.
Thanks very much, Advocate. And now we'll go into the discussion. And in the discussion, let's stay within the legal opinion and also the questions that have been asked and responded to. Let's not get into personal insults or reflect on matters that haven't been tabled. Just to be on the clear that we are talking about the opinion as it relates to the interdict itself. So today we'll confine ourselves to the interdict. If at the later stage we are going to have a discussion on the review, we'll have that discussion. But let's not get into the review application and the decision insofar as that's concerned. But let's confine our conversation to the interdict, and also please make a recommendation as you make your inputs in terms of which direction you believe the committee needs to take in this particular instance. There are two options. It's to oppose and then or to abide with a explanatory affidavit. So that's
sorry, Chair. As the external legal team, yes. I hope our job is done for the next session. Then may we be excused.
Yes, Advocate. You have given the opinion. Now it's for the committee to then deliberate on the opinion. Unless if there's anyone that has got a further question, maybe let me ask for the final round of questions before the external counsel can exit the meeting. Is there any member that's got a final question so that we get into the discussion point?
Yes.
No further.
Is there a final question?
Yes. Andy, as Honorable Mutama.
Honorable Mutama.
Yes.
On the question, please do ask a question.
Yes. Chair, I just want a confirmation because I suspect that in the event this matter is dragged beyond the term of office of President Ramaphosa, then this process will be rendered moot. In other words, it will become irrelevant. I just want to get a confirmation from the legal advisor there that indeed, if that is the case, then it put extraordinary pressure on this committee to try to finalize matters before the term of office come to an end. I thank you.
Thanks very much. Advocate, is that something you can give an opinion on?
Yes, indeed. Thank you, Chair. Yes, Honorable Mutama, you are correct. You can only impeach a sitting president. You cannot impeach a president who is no longer in office. So this will be time-bound and limited to the time when the president is and remain a sitting president. Thank you.
Thanks very much. Is that the final question before we get into the discussion?
My hand was up, Chair, but let me quickly go. Can the legal staff maybe advise which political parties have already opposed, and by when do the parties indicate, by when do they need to indicate if they want to oppose?
I'll ask Suen just on the timelines, just confirm the timelines, Suen.
Thank you, Chairperson. The parties need to indicate whether they're opposing by the 19th of June.
The 19th of June is tomorrow, Honorable Zungula, so by tomorrow. Thanks very much, and thanks very much, Advocate. Now it's for the committee to then discuss and make a decision. Thanks for the opinion, and thanks for the responses to the questions that honourable members have asked. We'll now go into the discussion as the committee, and you and your team, you can be excused from the meeting itself, and we appreciate the quick turnaround that you give this opinion. Much appreciated.
Thank you very much.
Honorable Chairperson. Honorable Chairperson.
Honorable Shope, is that the question?
Yes, I raised my hand long time ago, but it has been overtaken by events now. I'm ready to kick off the discussion.
All right, now we'll note you for the discussion.
Thank you.
If it's not for the question, then because I want to release the advocate so that the committee can get into discussion.
Chair. Thank you.
Thank you very much, Chairperson.
Chair, before the advocates leave.
Honorable Malema.
No, I'm sorry to do this. I think, Advocate, you may want to check the response you have given. A former president can be impeached. Because remember, when they leave with a package. So impeachment is not motion of no confidence. So you lose even the benefits. And you can still lose those benefits if you engage in a conduct that is not consistent with that of a former president. But it's a view I hold, so you may want to check it.
Now, it's a matter we may look at if we are requested formally. Then, but I take your point that is something to look at.
Thank you very much, and once again, thank you, Advocate.
Thank you very much.
We'll now get into the discussion. I've noted the hands. We'll start with the Honourable Trollip.
Chair, just before you note Honourable Trollip, sorry to do this. Shouldn't we do it party by party? Like we go through parties and then if there are other members from other parties who holds a different view, or you can say, let's say for instance ANC, and then someone from the ANC who leads the delegation gives an opinion, and then you ask if there's someone who wants to make follow-up or additions from the ANC. I think in that way, in that order, it will be a much more easier and doable. Thanks. Just my suggestion.
Thanks very much, Honorable Malema, and thanks for that suggestion. We can adopt that we go party by party, and if there's a member from that party, once we have concluded the parties that are in the meeting, want to make an addition, they can then make an addition. Is that agreed to, members, as the process from henceforth? I don't see any hand that's disagree. We'll start with the MK as the official opposition.
Thank you very much, Chairperson. I'm not going to congratulate you on your participation in the Comrades Marathon. I've already done that. Our position as the MK party is simply that we have been cited, meaning the impeachment committee has been cited. We have been dragged to court. Therefore, there is no option. We must oppose the interdict application purely on legal grounds. I am convinced that the president stands absolutely no chance in law at all. Purely on legal grounds, we must oppose the application, the interdict application. In fact, the law is very clear. President Zuma himself tried this when he wanted to evade imprisonment, and there was a judgment by Justice Mnguni in Natal to the effect that a high court may not interdict an order that emanates from the apex court. So I think the law is on our side. We must oppose it purely on legal principles and not get into the merits of the application, but purely on legal principles. I thank you. That is the position of the MK party. I thank you.
Yes, thanks very much. Just so that we are clear in terms of the the approach that I'm using when I call on parties. There was a new rule as it relates to the declarations that has been adopted by the National Assembly. So I'll apply that in terms of the order in which parties will make their views known. I will now go to the EFF.
Thank you very much, Chairperson. I think that we must all agree that we must oppose the interdict based on what the Honorable Klopp said. And also that the emphasis of the Constitutional Court was very clear that this must proceed and there should not be any kind of disturbance to this process. And opposing the interdict does not necessarily mean we are saying the president is guilty of anything. We are simply saying there is nothing in law that allows the president to stop this process, and that the High Court has got no jurisdiction over the matter. The Constitutional Court has ruled on this matter. And we believe that we should proceed as it were, Chair. And I don't think anyone who is up to the truth, who wants to know the truth, who wants to tell the truth, can be opposed to a process that is not saying you are guilty. That says what actually happened. The process is about to ask that question. We are not called an independent impeachment committee for no reason. The issue on the speaker will be dealt with at different levels, but at this level, the fact that we have cited, they too know that we are affected by this matter directly as an independent impeachment committee. And therefore, we should act independently, irrespective of what are the feelings or the position of the speaker on the matter. So I believe strongly that nothing stops us from opposing this interdict and ensuring that the work of this committee proceed uninterrupted. South Africans have been waiting for far too long now, and nothing should delay them anymore. And anything that seeks to delay the process where South Africans will get to know the truth should be, opposed. It's not that we are going to say the president is guilty or not. It's for the voter to know. It's for transparency. It's for everyone to know what really happened at that farm. And no one must stop that process. Thanks, Chair.
Thank you very much, Honorable Malema. The IFP. Is the IFP on the call? All right, there's no one from the IFP. The PA, Honorable Daniels.
Thank you, Honorable Chairperson. Honorable Chairperson, it has been explained to us that the opinion does not speak to the review. But I hold a view that we cannot just consider proceeding without considering the review. Now, we must not forget that the panel that was put together was required to determine whether sufficient evidence existed to show that the president committed the relevant prohibited conduct, warranting an impeachment inquiry. Now, it is contested that the panel determined that the information before it disclosed prima facie that the president may have committed the alleged violations or misconduct. Now, it is contested that the panel did not consider the significance of the rule between information and evidence. For the panel was provided with a lot of information, And it is the view of the president that that information did not translate to evidence, and therefore it needed to be tested. So the clarity that I seek is there any prospects where the court may rule in favor of the review application brought by the president? And even if such a prospect is a 5% or a 10% prospect, but there is a prospect of such application being considered and ruled in favor of the review application. And if it is indeed so, will that not open up the impeachment committee to fruitless and wasteful expenditure? Because by no means, don't get me wrong, I'm by no means advocating that we must stall the work and the duties of the impeachment committee. I'm merely asking, with a pending case relating to the review application brought by the president, and considering that this particular matter has been coming on for a number of years, and wanting to guard against the slightest prospects of the application for the review being ruled in favor of the president, what harm will it do us to sit back and wait for the outcome of that application and then take a decision from there? Must we continue with the impeachment processes through this committee? My answer is yes. Must we do it now? I believe it will be reckless, because as much as the country is waiting to hear and see how this is going to play out, I really think it will be responsible for us to wait on the outcome of the application of the review before we continue with the proceedings of the impeachment committee. So do we then oppose? My answer is, I do not believe that we need to oppose the application of the interdict, but let's rather wait for the court to make the ruling. And it's not long, there are dates set when those things are going to be before the court. So I respectfully request that we consider not to oppose the interdict, and also to wait for the outcome of the review application. And thereafter, we can continue with the work as we are supposed to do. Thank you, Chairperson.
Thank you very much, Honorable Daniels. Now move to the Freedom Front Plus, Honorable Vessels. Honorable Vessels, are you, if you are speaking, you are muted. Because it says here you are in the meeting. All right, I will then pass and go to Honorable Trolip, Action SA.
Thank you very much, Chairperson. Chair, I believe Action SA's position is on the record already in that I wrote to you and the Speaker in this regard, but I want to put it on the record in this meeting. First of all, we note the deadline of responding by tomorrow. So thank you very much for convening this meeting today. We believe that the urgent interdict must be opposed. This matter is not urgent. It's 4 years old. And we, as a committee, have been cited through you as our representative. So we've been cited and we must oppose. I want to remind the committee that this matter is before us because Parliament balked previously from doing what it should have done. And the Concourt is functus officio in this matter. And it has issued a final order that Parliament must do what Parliament must do. And the only way that that can be stopped is that if there is any malafides, fraud, or corruption, to empower an interdictory relief. And I don't believe there is or there are any malafide, fraud or corruption in this matter. Also, Chairperson, the Concord judgment is not appealable, and a lower court can't stay, vary or rescind a constitutional court judgment as per the opinion we've received and mentioned in section 18, that it may not competently displace a constitutional court order. Chairperson, if we do not oppose this, Action SA believes it would be tantamount to this committee self-emasculating or neutering itself. The Section 89 Impeachment Committee has got specific and very special work to do, and we as Action SA will have no part in any exercise that serves to emasculate this committee. It's one of the most important committees of Parliament, and we need to defend Parliament in every instance, and also we need to defend the Constitution and also the institution of the presidency. So I believe it's imperative and incumbent upon you, Chair, to oppose this interdict, which is not urgent. Thank you.
Thanks very much, Honorable Trollip. Let me just check once again. I'll come to you, Honorable Swart. Let me check Honorable Khadeb of the IFP, if maybe your network is back on. If you can hear me, you can come in if you are there. There's no response from the IFP. Checking once again for Honorable Vessels of the Freedom Front Plus. Can you hear us now? And can you state your position? There's no response. We then move. ACDP, Honorable Swart.
No, thank you, Chair. Chair, we addressed a letter from the ACDP side to the Speaker, reminding the Speaker and yourself of the Constitutional Court's ruling at paragraph 94, where the court said the National Assembly's oversight role over the President lies at the heart of our constitutional scheme, and accountability of the President is one of the foundational values of our Constitution, and the National Assembly bears the responsibility to ensure that the President is held accountable. We also said this is unprecedented as an impeachment process, and every step of the process must be carefully considered given the precedents that it creates. Now, Chair, the Senior Counsel made it very clear in paragraph 32. It says, in this context, the IC's compliance with the Concord's order is not optional. It is a legal and constitutional imperative. The IC, that is us as a committee, cannot suspend its compliance pending the outcome of litigation in a lower court. The IC must proceed with its work and defend its right to proceed against any attempt to interdict that compliance. Chairperson, it is very clear, and that's why I wrote my letter on behalf of the ACDP, pleading with the Speaker to oppose the application, as well as you as Chairman of the committee. What is also important is the point the ACDP raised about the time should there be appeals raised, and that brings Rule 129M, which says this process must be finalized within a reasonable time frame. It also brings Section 237 of the Constitution, that our constitutional duties must be fulfilled without delay. Chairperson, other speakers have indicated the public are demanding to know what happened. Now, not in months or years' time, should there be appeals to the Constitutional Court. And Chairperson, it's important to note that the President could have approached the Constitutional Court for a stay of its order. He chose to approach the Western Cape High Court, which in our view, which is substantiated by the Senior Counsel, does not have jurisdiction over this matter given the Constitutional Court's ruling. So, Chairperson, with that having been said, we strongly urge both the Speaker and this committee to actively oppose the interim application. Thank you, Chairperson.
Thank you very much, Honorable Swart. UDM, Honorable Nkwakwa.
Thank you very much, Chairperson. I'm glad that Honorable Steve Swart has quoted directly from the Concord Order. The Concord Order states it clearly that it's the National Assembly. I want to state the point that we are of the view that by citing you, we are being sent on a wild goose chase by expecting us to challenge matters that we can't do in our own right. Let me state a point clearly, Chairperson. We cannot be established by Parliament, constituted in terms of its rules, and then be expected to operate independently of the very same institution that created us, to which we remain accountable. It is not correct. I listened to the sequence of events. The committee was not established by the Concord, it was established by Parliament. We were guided even back then by the Concord judgment, which said you can't deal with the motion of no confidence the same way that you deal with the impeachment process. We had to set the bar higher. Those who were part of the debate in 2022 December will remember that was the main crux of our argument when we were saying do a secret ballot speaker. So if Parliament is the source of our mandate and authority, it is therefore, in our view, legally and constitutionally untenable to suggest that a committee can function as though it was separate from the institution that established it. You will recall, Chairperson, that we are here because of Section 57 of the Constitution. It is Section 57 of the Constitution about dealing with internal arrangements of Parliament that gives the National Assembly, because that section deals exactly with the powers of the National Assembly, that it can delegate its work and it will do it via committees. We are one such a committee. So we should not, when we discuss the question, which is very important, of independence and impartiality, assume that it's independence to say that institutionally we're independent of Parliament. No. The independence that is being referred to here is impartiality, as the people who are going to make sure that we hold the president to account, right? So that's where we are. So the Constitution, if you look at section, I'm not a lawyer, you'll forgive me, but that's my understanding, and our understanding is that it envisages that Parliament as the central locus of political accountability. Parliament, with its committees serving as mechanisms through which that accountability is exercised, rather than us seeing this committee as being completely independent. In essence, what am I saying, Chair? What am I saying? What are we saying? We're saying yes to us holding the president accountable, but rather challenging the interdict. But perhaps what we should do is to do it via the correct processes, where it's not the committee itself, but we do it via the speaker. The speaker is the authority of the national, exercises that authority on behalf of the institution. I want to remind colleagues, when during the Zondo Commission of Inquiry, we had a problem when Speaker was Thandi Mutise. One of the complaints we had as the institution is that the Zondo Commission kept on writing to individual members of Parliament and portfolio committees without addressing the institution directly. And that was our gripe. I was requested to go there and testify. I said, on the basis of what? I can't be called as Ngabamzi Kwangwa when I exercise my authority in a portfolio committee on behalf of Parliament as an institution. So yes, indeed, let's challenge it, but do so via Parliament. I do believe that as this committee, once we have reached a resolution that says we want to challenge and we instruct the speaker, there should be no reason for the speaker to say she can't do that when we are exercising that independence and impartiality and trying to get the president to account to Parliament or to this committee on behalf of the National Assembly that elected him into office. Thank you.
Thank you very much, Honorable Nkwankwa. Bossa, Honorable Imani.
Thank you, Chairperson. I think without trying to repeat what everybody else has said, firstly, I think as Build One South Africa, I'd affirm the view that we must oppose the interdict, fundamentally because I think on what the establishment of law, the establishment of the supremacy of parliament, but thirdly, the precedent could be devastating for future processes. The legal counsel has already stated to us that this process must be fair and defend the rights of all parties, including the president, by the way, and the rights of parliament. Therefore, in that light, if we fail to appeal this matter, we would then set up a situation where in future, another member of the executive faced with similar or different circumstances could be reliant on saying, I could interdict the work of parliament. And I just think that that is wrong, just not only in terms of this current case, but it is wrong in terms of the constitutional arrangements as to where the executive accounts. The second matter is simply that, Chairperson, that an appeal, as another honorable member stated, does not pronounce guilt on the part of the president. Our job is inquisitorial, as the legal team has already stated. Therefore, I would urge that, in fact, the committee must then deliberate further on its own program and figure out what it needs to do. Thirdly and lastly, Chairperson, I hold the absolute view that I was not completely dissuaded by the legal counsel that a declarator from the Concord should not be sought. And that can be done, as Honorable Kwankwa stated, through the Speaker, to say that this matter, the Constitutional Court has already ruled on this matter. We cannot be going as though we were going to go in a lower court and then at the SCA, etc. We need to settle this matter so as to circumvent further delays on the basis of appeals, etc. So I still maintain that through the Speaker, I'd like to inquire, or through you, Chairperson, whether or not an application to the Concord for a declarator, given that all of these legal matters are coming through on both the application and the interdict, must be sought so that we don't end up with extended delays. I really believe we need to get to the business of the work so that this matter is behind us. I maintain that we are best served as South Africans by getting over this matter so that the president can focus on the work and the duty at hand, which the matters of South Africans are complicated beyond this issue and need everyone's focus. So may I request that question be addressed through the Speaker's legal counsel? I would appreciate that. Thank you very much.
Thanks very much, Honorable Maimane. We now move to the ATM, Honorable Zungula.
Thank you, Chair. Firstly, we are in this process because of a constitutional court order, which was very clear when it comes to how we should proceed and the manner in which we must proceed. Therefore, we can't then accept that an entire head of the state would want not only to undermine Parliament, but also undermine that particular Concord order and in effect undermine the Constitutional Court, because this process is a result of litigation that was adjudicated by the Concord. So to seek to interdict Parliament violates the constitutional obligation of Parliament as espoused in Section 55 of the Constitution of holding him accountable. It also violates the separation of powers principle, also violates the Constitutional Court and in fact the entire state, therefore. So in that, Chair, I want to move that the decision we must take today must be to defend the independence of Parliament and for Parliament to dictate or to direct its own programs and processes. So we must oppose. The second issue I want to raise is that precedents when it comes to the Section 194 process, which dealt with the impeachment of Advocate Mkhwebane, the Speaker, as the head of the institution, as the head of this legislative arm of the state, went to court to oppose Advocate Mkhwebane's interdict. So we must be principled as Parliament to say it must be the Speaker representing the institution. We must not create a case where it might appear as if it is only this independent, this impeachment committee that is opposing, and the institution, is fine with the application to interdict the process. This process must be defended by the Speaker of Parliament, as she is the head of the institution. That is, Chair, I think the most important thing that we want to highlight. I don't know how, given the fact that the meeting and the deadline to oppose, to file a notice to oppose is tomorrow. But like we've done now, we can make even virtual meetings in the forums of other forums of Parliament. But if I can advance, Chair, that if we frame our resolution to say we are taking this resolution as the impeachment committee, but due to the issues of principle and precedence, we advance that opposition must be done by the Speaker of Parliament. Thank you.
Thanks very much, Honorable Zungula. NCC, Honorable Adams. If you are still on the call, I know that you are about to board. All right, looks like not in the meeting. Honorable Musa Al-Jama.
Thank you, Honorable Chair. As Al-Jama, in the interest of fairness, transparency, and legal certainty, our party is of the view that the committee should ensure that an independent second legal opinion is obtained before any final decision is taken. And our party is of the view that presently the present president should apply for a stay of order. And to the extent that the president get a second opinion by challenging the High Court report. I thank you so much, Chairperson.
Thanks very much. UAT, Honorable Matatse.
Thank you, Chairperson. Chairperson, I think at the heart of this matter lies the doctrine of separation of powers. Now, the Constitution entrusted the National Assembly with the solemn responsibility of holding the executive accountable. Now, this process is then one of the most important accountability mechanisms available to Parliament. To prevent the committee from merely commencing its inquiry will be to frustrate the Parliament constitutional oversight function before any evidence has been tested. Now, because the committee has been cited through its chairperson, which is you, sir, I also support that the committee must oppose the interdict application purely on legal principles, as has been stated by Dr. Hlophe. Chairperson, I submit.
Thanks very much. Before I call on the DA, checking for the final time, IFP. No response. Final time, Freedom Front Plus.
Thank you, Chair. I'm covered. Nothing to add at this stage.
When you say covered, is that the oppose or covered abide?
Chair, I agree that we should oppose. Yes, I agree that we should oppose.
Thanks very much. Thanks very much. Now go to the DA.
Thank you, Chair. Good morning to everyone again. Chairperson, our view is this, that we certainly lobby the Speaker very vigorously to oppose this application for an interdict, because the work of the committee must proceed. And until there's an interdict prohibiting us from going ahead, we must go ahead, and no delay should be countenanced. However, I disagree quite sharply that the committee can do it, Chair. Legally speaking, in my view, a Section 89 impeachment committee does not have locus standi to litigate in its own name. The committee is an extension of the National Assembly and lacks distinct or separate legal personality. The committee derives its powers entirely from the Constitution of the Republic and from the rules of the National Assembly. And we are established to assist Parliament in carrying out its constitutional obligations. Legal action is required to be instituted or defended by the Speaker of the National Assembly, and it must be done in her name as the juristic entity. So, Chair, I don't think that we as the committee can litigate on our own behalf, but the committee should, in my view, take a decision to vigorously lobby the Speaker to do so. Thank you.
Thanks very much. And finally, the ANC.
Thank you very much, Chairperson, and greetings to yourself and other members, and congratulations again. The first issue is that we're not convinced about the independence of the committee to can litigate or oppose or abide by itself. It is a creation of the National Assembly, which is Parliament, and it is created with a constitutional duty to conduct its work fairly and impartially, not independently, impartially. I agree with Honorable Kwankwa that the reference of independence was solely to cover impartiality. But given the fact that the President has approached the courts, we think that the committee should respect the judicial process and abide by the court's determination. The committee's role is not to defend the Section 89 panel report, but to conduct an objective inquiry. Should the court permit the process to continue, by abiding, the committee protects both the separation of power and the integrity of its proceeding. So we are taking a posture that we should abide, Chairperson, and in doing so, we must file an explanatory affidavit, as the SC has said. The explanatory affidavit must stay far, very far, and clear of the merits and demerits of the case in point, so that we maintain the impartiality of the committee. We would want the committee to engage the Speaker. That should be the one doing the opposing if the committee agrees to oppose, or abiding if we agree to abide, not this committee, because we believe that this is a creature of the National Assembly. Thank you very much.
Thank you very much, members. I just want to check if there's any member of the parties that wants to state a different position from that that has been stated by the principal representative, before I sum up the discussion and the recommendations of the parties.
Right. Chairperson, sorry, Chair, I've put up my hand. I do not want to agree with the position that I put. I agree fully. I just want to get clarity from you, Chair, when you wrap up. You have been cited as a respondent. Can you give us clarity on your position and what you will be doing as a respondent, as the chairperson of this committee, who is our nominee? You are the nominee of this committee and you've been cited. You need to tell us how you're going to deal with that, especially in light of the two submissions made last, that the committee doesn't have locus standi as per the DA, and the ANC says that we should be asking the Speaker to respond on our behalf. So I think we need you to clarify that position. Thank you, Chair.
All right. Can I please ask the hands to be taken down for now, so that we can have a new set of hands if there's any new set of hands? Honorable Ngitama, is that a new hand, or you are going to contribute to the discussion? Or you want to take a different position from the one that has been stated by Honorable Hlope?
No, sorry, Chair, it's a legacy hand, so.
All right, thanks. Honorable Michalakis, is that a different matter before I sum up the conversation?
Thank you, Chairperson. Good morning to all of you. Chairperson, it's a new submission, or just to add on. Chairperson, I want to just indicate one or two things. The first one is, I want to go back to the original role of the Speaker, and I want to perhaps just, if the committee will indulge me, quote, perhaps from another place, Speaker Lenthal, who said, "I have neither eyes to see nor tongue to speak in this place, but as the House is pleased to direct me, in whose service I am." That is a very, very old and ancient quote of the role of the Speaker, who is in service of the National Assembly and whose sole prerogative and job is to ensure that this place is able to fulfill its function. Now, Chairperson, the Interdict application itself is directed at preventing this House from fulfilling its obligation, which the Constitutional Court has given it. My submission is that we are not just an idle bystander in this application, but it affects Parliament very directly, and it speaks to the role that Parliament must fulfill in terms of the Constitutional Court. My submission to you, Chairperson, is that the Speaker's role in all of this is to function in a way in which the House directs her to function. So my request to you would be that if this committee today, and it should, if this committee today decides that this needs to be opposed, that the Speaker should act on our instruction and oppose the application. And I want you to please keep that in mind when you answer the question of Honourable Trollop, which is a very valid question, in how your role, how you fit into this equation. The Speaker has an obligation to act on the request and the instruction of this committee. And I would therefore implore you to convey that instruction that this matter needs to be opposed and that the Speaker should act as our representative in this application, but that she should act in line with the wishes of this committee, which is to ultimately oppose that application. Thank you.
Thanks very much. So that I don't want to invite so many hands, just to check, Honorable Daniels, Honorable Zungula, Honorable Malema, is it matters of emphasis that you want to put? Or you are supplementing the inputs that you had made? Honorable Daniels, just a quick one.
Thank you, Chairperson.
I'll give you a minute. I'll give each
That's
one
enough.
a minute so that we move towards closure.
Thank you, Chairperson. Thank you, Chairperson. Chairperson, I'm not moving from our position that we must not oppose. The opinion, Chairperson, advises the committee both to maintain strict neutrality and to actively oppose the interdict. That's opinion, while conceding in paragraph 44 that the committee may instead file a notice to abide. Now, having said that, I want us to appreciate that this is nothing more than just an opinion. And I'm sure if we source an opinion from a different firm, we may come with a different opinion. And I want you to consider, Chairperson, before you take your final determination, that maybe to get another opinion, because one opinion is not necessarily law, but just as a guidance. And I firmly believe that for you to apply your own mind, because the question asked by Honourable Trollop is going to lean to just, we cannot be bounded by this one single opinion, Chairperson, because it already contradicts itself.
Your minute has
Thank you,
expired.
Chairperson.
Honourable Zungula, 1 minute.
Thank you, Chair. Firstly, let me deal with the question whether the committee has got local standing to oppose. The answer is yes. That is what the legal opinion says. Secondly, there is precedence in that in the Section 194 committee, that dealt with the impeachment of Advocate Mkhwebane. The chairperson at the time, Ukubutile Dyantyie, opposed all of the cases and the interdicts that was filed by Advocate Mkhwebane. Therefore, even with this committee, we should oppose. This committee should oppose, and also including opposing, we must petition the Speaker to oppose on behalf of Parliament. We need to be the ones that protect the committee to be able to do its work. And Chair, we can't then be wanting to do many other opinions. Like the deadline to institute or to file an intention to oppose is tomorrow. Now we must have another opinion and then discuss, and then another person will say, no, let's have another opinion. No, Chair, let's just
Thank
move
you,
on.
Honorable Zongola. Your minute is up. Honorable Malema, 1 minute.
Thanks, Chair. I think that even the President knows that we have a duty, if we so wish, to participate directly as a committee. And it will not be naive or stupid of a president to cite you if we had no role to play. There is a precedence Honorable Zongola spoke to. The principle is we must oppose. The nitty-gritties of it, you comrades can deal with it at that level. But the principle is that we're opposing and you're going to have a discussion. Obvious, you cannot just oppose without having a discussion with the Speaker. And she can as well just say, no, look, let's do one thing. I will oppose this thing and then proceed in that way. If she has got a different view, you proceed on your own on behalf of the committee. It happened before where the committee responded to an interdict of impeachment. It's not for the first time. And to be asked to just look at opinion as an opinion, exactly what the courts have warned against. It's an opinion, yes, but you have to have good reasons why you are ignoring that opinion. You can't just say it's a mere opinion. That's what they said about the panel report. And that's why we are where we are now. Really, we cannot go back there. Let's oppose, and you are going to oppose on our behalf.
Thank you, Honorable Malema. Your minute is up. Honorable Direko, a minute. Honorable Direko.
All right. Thank you, Chair. Thank you, Chair. My apologies, my network is a bit bad. Chair, I want to also emphasize that as members of the impeachment committee, we have a responsibility to ensure that the process is fair, objective, and credible. For this reason, I believe that the committee should abide by the court process rather than being actively opposing the interdict. The reason why I'm saying that is that our role is to conduct a fair process, not to defend a report in court, which is not even our report. So if we actively oppose the interdict, we then risk creating a perception that we have already taken a position on the matter. So I then support what our whip has just said, that let's rather abide by the court and ensure that the process is fair. We are not seen being taken aside or being on the other side of that of the other people. Thank you. Chair.
Your minute is up. Honorable Nola, 1 minute.
Chair, I see no compelling legal reasons why we should aggressively go for a fully blown opposition to the application. Worst of it, Chair, it's us who are raising serious issues, critical issues of the jurisdiction of the High Court, and our backbone is the decision handed down by the Chief Justice in the Apex Court. So the law is already still on our side. So I think it is important, Chair, that we file a notice to abide with a declaratory affidavit where we advance the legal principles that we agree upon here in this meeting. So that's what I think we should do, Chair, without going fully blown on opposition. For that matter, Chair, we're not interdicted now. We're still going to do our work, doing the terms of reference, appointing the evidence leaders, and all that. We are still going to do that work. In the meantime, no one has interdicted us. But I think we are comfortable, but that the law is on our side. So let's allow the courts to give us that
Thank you very much, Honorable Ngola. Your minute is up. Honorable Dagmo, 1 minute.
Thanks again, Chair. Just to amplify the points made by Honorable Hlauli, Direko, and Ngola. The issue is that we, using language such as vigorously oppose, begins to undermine the critical need for us to be impartial. So I support that issue, but also want to specifically say that we have a chair of this committee, we have a speaker, both have been cited. I want to propose formally that there needs to be an engagement between the chair and the speaker. It's a serious concern if we're going to have no consultation given arguments that have been raised before. So I propose that once the committee has a view, the chairperson needs to represent us in an engagement with the speaker. Thank you.
Thank you very much. Honorable Khafau.
Nakenzam Tlamashtulo, there is nobody here who should be confused about our responsibility to defend our existence. Our existence as the impeachment committee is mandated by the Concord. The National Assembly has given us full powers to exist. The rules around our existence have been adopted. So whether or not the President of the Republic does not like our existence or is trying to find ways around whether our existence must exist or not, that's not an us problem. And therefore, it would be incredibly irresponsible of us as the impeachment committee to sit back in a fight that seeks to nullify our existence. So our job is clear. We must proceed with the impeachment proceedings. We do not need to wait for the interdict to decide on our behalf. We can have a say ourselves to say, we are constitutionally mandated to continue. If you're saying we must not continue, we say we must continue. And there's nothing wrong with being legally in court on record saying that. So it is important that we oppose the interdict. Thank you.
Thank you very much. I have 4 last speakers, and then after these 4 speakers, because I'm not hearing any new addition rather than the emphasis of the points that have been made before. So the last speaker will be Honorable Mautwe. So I'll now go to Honorable Musa, Honorable Nitama, Honorable Maimani, and then the last speaker will be Honorable Mautwe, and then I will sum up the conversation and answer the question that has been asked in terms of the decision. Honorable Musa, your minute.
Thank you so much, Honorable Chair. The committee should exercise its right and mandate to a second legal opinion. We're dealing with the president, and I think it is important in terms of the national interests of this country that we exercise our right and ensure that a second legal opinion is sought. I am strong of that view. Thank you so much, Honorable Chair.
Thank you very much. Honorable Ngitama, your minute start now.
Thank you, Chair. Chair, the proposal for another opinion is practically impossible at this stage. We have the deadline to meet. But I want to emphasize also that this committee must, on its own right, oppose the matter. Because if this matter, we don't even know what argument the speakers is likely to take the line of her position. So we here have a responsibility to protect the integrity of this process and take much more seriously the responsibility given by the Constitutional Court. Therefore, Chair, I do strongly suggest that we oppose this matter in the name of this particular committee so that we move and resolve this matter. Thank you.
Thank you very much. The last speaker is Honorable Mautwe.
No, Chairperson, you've skipped me.
Oh, sorry. The hand kind of disappeared, Honorable Maimani. I thought you were covered. Honorable Maimani?
No, I think
Honorable Kwankwa, I had closed the speaking list, unless it's a point of exigence. Honorable Maimani?
Chairperson, the legal team that was on this call made it clear we have been invited to a fight. Therefore, the question of whether the committee can
oppose in its own right is established on the principle of being cited through you. So I think for us to debate, I take the comments about the speaker, etc. I would argue that we need to respond, we need to oppose, and ultimately the work of the committee must continue. Because, Chairperson, for us to delay this matter and not want to file a response and wait for another opinion will in fact undermine the work of this committee. We will going around on these issues over and over again in courts all the time. And I reaffirm, let's get a declarator and get the work of the committee on the go. Thank you.
Thanks very much. Honorable Maotwe.
Thank you very much, Chair. Chair, one, we need to oppose in line with the legal opinion that you sought on behalf of all of us. We can't sit and just wait and be bystanders, because the interdict seeks to halt the work that we need to do as this committee. And this SC went at length to explain the legality of it and what will be our legal basis on it. So there's no debate about it. Number two, Chair, the deadline for us filing the papers is tomorrow. So there's no need for us to seek a second opinion. It's a waste of time, it's a waste of money, the resources, the little resources we have as a country. And Chair, the last one is, we doubt the speaker, and we should actually come out as this committee with a resolution that says the speaker must oppose, because we have already written as the EFF to the speaker to oppose. The ACDP earlier on did indicate that they wrote to the speaker to oppose. I think even Action SA did alluded to that fact. And she's not doing anything. And therefore the resolution by this committee is that she should also oppose. Thank you, Chair.
Honorable Kwankwa, I'm giving you 53 seconds.
You can't. Kalog, remember that was the submission of the party. Now I must state whether I agree with it or not. I'm kidding, Chair. I think there's a third way here that Honorable Malema has proposed, which I agree with entirely. Because the question is, it's either we say we have two options, either the speaker or the committee opposes. Now we're saying let's have a resolution that is firm enough on this question that you will take to the speaker and have a discussion with the speaker. In the event that the speaker does not oppose, the committee should oppose, so that we don't sit back and twiddle our thumbs and do nothing and be helpless because the speaker has not moved on the issue. I think to us that is a very good way forward.
Thank you very much, honorable members, and thanks for the inputs. The points that have been made, the prevailing opinion based on the inputs that have been made by the parties is that the committee needs to oppose the urgent application of an interdict by the president. So that is the prevailing opinion of the committee. I don't even need to put it to a vote. The numbers are such that those that are on the side of opposing, it's they are in the majority. To the question that was asked by Honorable Trollip, so I, as the chairperson of the impeachment committee, align myself with the prevailing opinion of the members of this committee that we should oppose the application, and I will do so on behalf of the committee. So it will not just be me in my individual capacity, because I was not cited in my individual capacity, but as a chairperson of this committee, I intend to represent the committee in opposing the interdict application by the president, and as it was proposed, will then petition the speaker to also join in opposing this application. But if the speaker decides not to oppose the application, as the chairperson of the committee and the second respondent to the interdict application, I will represent the committee in opposing the application. The view in terms of seeking a second legal opinion, given the time that we have, that we need to indicate by tomorrow, I don't think it will be, we'll have enough time to be able to get another opinion, still have another conversation. So the prevailing view of opposing that stand, and that's what I'm going to file on behalf of the committee, start working with the legal team. And if there's a question, one of the questions that might very well need to be answered, and we'll try to get it answered. It's whether, as a committee, we can adopt or we can oppose if the speaker decides not to oppose. But given what the legal opinion that we have received, I think we are on a good footing in that regard. But I will still petition the speaker to join us in opposing this interdict. That's the prevailing opinion of the committee, and is that going to be taken forward by the second respondent to the interdict, which is myself as the chairperson of the committee. So that concludes the discussion on this particular matter. Just to indicate, honorable members, that the work of the committee has not been interdicted. It continues. We will have our meeting next week on Wednesday, the 24th of June at 10 o'clock, where, amongst others, we are going to consider our draft terms of reference and also the process to appoint evidence leaders. I have said this when I was elected, that we are going to focus on the things that are in our control. What's in our control is to get the process on the go. The things that are going to happen outside of our control, we are not going to focus on them. We'll continue with the work of the committee until being asked or told to do otherwise by a court of law. So until such time, we are proceeding as the impeachment committee with our preparatory work, and we will see each other next week, Wednesday, in person, 10 o'clock at the Good Hope Center. Thank you very much, honorable members. The meeting is thus adjourned. Councillor Smith.
Hey, Councillor
Chair. Oh, Sim Shamai Stulo.
Can say.
I can't some stool.